You're welcome back. This is Newsfile. It's the most authoritative news analysis platform, and here on Newsfile, we put Ghana first. So you remember that I introduced two topics. I spoke about that we're going to deal also with the question of flooding, where the Auditor General's special report reveals that as much as 117 million cedis was spent between 2015 and 2019 trying to resolve the flooding, and then the housing minister, Francis Asenso Boakye, also has told us that some 450 million has been spent since 2017. And we were hoping to try to find out how the country still, even upon this expenditure, continues to count some 1,446 flood events, which have killed some 510 people, injured 309 others in 6 years. So my bigger question was whether we are jinxed and doomed to the annual ritual of the devastation for which these huge sums of money or scarce resources have been reportedly spent. And also my question as to whether sanitation is euphemism for corruption. We will find time for that perhaps next week, because this issue comes up, we discuss all the time. We come back to the same situation. I remember we will sit here, Kukubaku say, I'm tired. If you like, play back my sound from the last year, and it represents the same thing. You know, what's just wrong with us? Okay, now, when you listen to Bright Simmons, briefly, let me hear from you after listening to him.
Okay, good. So, like the way it's lived up to his billing, you mentioned that he was going to bring a different perspective, and sure enough, he's brought it, more than enough of that. So it further muddies the waters. So look, not to talk plenty. What is clear at the end of this is that, please, let's revoke the EI 144. Let's not give back these lands. That's very clear. And that's what, if you follow social media platforms, look, classmates, lawyers, everywhere, that's what they're saying. Because others have described the forest as the lungs of Accra.
That's right.
That the Achimota forest
is
the lungs of Accra, a big carbon sink. Let's not do it. And in any event, to cap it all, the Supreme Court has made it clear in the Need Pubichu versus Attorney General that Article 20 is prospective. Anything that happened before the Constitution 1992, a closed book. So there's no basis, even though
for anybody to come and say compensate me or something.
So honorable, the compassionate grounds, though, we are resisting it.
No, compassionate grounds is different from compensation.
If that compassionate ground takes into account those who benefited from it, what was paid earlier.
That is the
who have made a good life.
Well, what I'm saying is that is the dimension that has been brought in by Bright Simmons. Okay? And clearly, we did not look at the petition of OWU on the basis of non-payment of compensation. And I agree entirely with Bright Simmons. And I've said consistently in my releases that evidence that came before me so clearly that...
Do you agree?
What I'm saying is that...
When he says, right now, what ought to be done is revoke EI 1744, rescind it.
Yes.
Let's not say we have degazetted some area, it is no more a forest reserve.
I welcome and support calls from the general public for the reversal of the declassification of the portions of Achimota for forest reserve as contained in the EI 144, and for an independent inquiry to be launched into these matters to ascertain the truth.
Okay, great. So he's reading from a statement he had issued to react to some of the matters that had come up. And I'll ask you earlier why you think that, and as you can see the trajectory, I just looked at something curious a while ago. Attorney General is not even in the picture. He's only simply being asked, can you draft an EI for us? Not seeking advice from Attorney General first. But my question was, by law, is it not the Lands Commission that's supposed to be doing this job? And we ended up having the Forestry Commission, whose boss we now have found huge acres of these lands in his will.
Well, that confusion arises from the Constitution The Constitution says that and that is Article 269. It is subject to the provisions of this Constitution. Parliament shall, by or under an Act of Parliament, provide for the establishment within 6 months after Parliament first meets, after the coming into force of this Constitution, of a Minerals Commission, a Forestry Commission, a Fisheries Commission, and such other commissions as Parliament may determine, which shall be responsible for the regulation and management of the utilization of the natural resources concerned and the coordination of policies in relation to them.
So it will deal with policy.
It will deal
There is a lands commission.
No, it doesn't even deal with the coordination of policy. It doesn't deal with policy.
Okay.
It deals with the regulation and management of the utilization of the natural resource. Now, so Forestry Commission, all forests, okay, in Ghana is under the management, the regulation and management of the Forest Reserve. The control of the forest is under Forest Reserve.
Yeah,
now,
and their responsibility is limited to giving you a permit
to the forest,
to it, not to give you a portion of it.
So there is a decision of the High Court of Tamale, affirmed by the Court of Appeal, I think so, of a case in which the Lands Commission had given grants of portions of the Achimota of the Tamale forest to individuals. The Forestry Commission took the matter to court and won.
Right. So the Forestry Commission was contesting the grants. Not that it has the power to grant.
Yes. So,
but that you have granted what you shouldn't grant.
Yes.
Good.
Not once it's still
so
a
come back to my
let me
question.
come back to your question. Your question is simply, why didn't the Lands Commission grant? And that is what clearly is the issue now. The Lands Commission could not have granted because that was a forest reserve. And that's a forest reserve.
It grants you,
No,
and then
so
you get the
explain-
permit from the Forest
I'm explaining
Commission.
to you. I'm explaining to you.
Yes.
The only way I understood the declassification was that, look, immediately you declassify a forest reserve, it becomes a public land.
That's right.
That's what the way I understood the declassification. Immediately you declassify a forest reserve, it becomes a public land. And then
Rather public land.
yes,
So rather,
Yes.
see, it's a land.
Yes.
The land is always been
Not the-
vested in the president too. The way I understand it
you
is
see,
that
so when you declassify, it becomes a public land, and that land then can only be given by the Lands Commission.
Okay.
That's how I understood it.
Honorable, let me come this
Okay,
way. The way I
thank you.
see it is that
We
in
are back to the same
1927,
issue here.
you
Right.
see, the acquisition says the president is taking trust for the people. So the land has always been a public land, but what grows on it is the forest. So as long as you are cultivating or when you're running a Forestry Commission manages that. As and when it's no longer deemed necessary for a forest, then we can use it for other purposes. It's always been a
So
public
yes,
land.
I agree with you. It's always a public land.
Yes.
I agree with you. But when something grows on the public land, and the management and control of that grows on the public land is vested in the
Forestry
Commission,
Yes.
how do you deal with the land without the Forestry Commission?
Very good. So as and when the Forestry Commission no longer deems it necessary, they just tell government. Well,
Yes, so I agree with you. So the Forestry Commission should first of all say that, we don't think that this land can support any activity of the forest.
Right. So now let's come to what the revelations from the will.
Sam, just I
say
beg one
to you.
sentence
Yes.
before you go. So please, what looms live today at this table is that Mr. Afaridate, whilst Honorable was in office, was signing leases on the blind side of
yes.
Honorable. Please,
That is why-
Mr. Jinapo, at your committee, we will need and we are begging that it should be done in public. Mr. Afaridate and his top management must come and answer
why
how they could give leases on the
without the
blind
consent of
side of the minister and the Lands Commission.
Yes.
That's very important.
Very important.
Right.
Yes.
Yes. So on the part of the will, is Jinapo's press release declaring those acquisitions void, effective?
Oh, sure. I'll go with him 150%. Oh, yes. Listen, in matters like this, so we are taking the position that nothing passed because the place still remains a forest. Nemo that called
non-cohabit. Yeah.
So
You
nothing
can't
passed.
give what you don't have.
Yes, and I think Ace even brought a good case on the platform, a Supreme Court decision, where the person giving doesn't even own it. So if you go and write in your will that I'm giving X, Y, Z, when you have not properly acquired it, nothing will pass.
Okay.
So that would be brutal fulfillment. Like that's empty speech in law, right? Yes. So I like, you see, the way he's been very decisive. That's good. That's just what we need in this public space. Don't wait. It's also rule of law. He has looked at the Constitution with the advice of the Attorney General. They think nothing is passed. If Mr. Sir John's family, could you also freeze? If they think otherwise, well, the courts are there. They can challenge. But we don't need to go to court to rather contest it. No, it's clear to the minister and the Attorney General that nothing passed under the will. So those lands will remain public lands. If the family has
that action, he says, is on the advice of the Attorney General.
Very good.
Yes, advice.
Yes, so I support it. That's it. It's better. And that is just what we need. You say, yes, and so you should just go on with it. That's it.
So you see, I have a slightly different view. Nothing passes. I agree with the general principle. Nothing, you can't acquire something illegally and pass it. So you must first of all establish the mode of acquisition.
Right.
Yeah, that's very important. That all of us need to understand, because we all know that Sir John went to the Forestry Commission in March 2017. We do not know of any attempts by government to declassify any portion of the Achimota forest. And we do not know or have no knowledge of any attempts by the Lands and Natural Resources Ministry to declassify the Ramsar site. While the Ramsar site is protected under UNESCO, and that's why it is called Ramsar, the Forestry Commission is protected under domestic legislation. And for a person to say that I have acquired portions of the Ramsar site and pass on my title to my successors in title, raises many issues, especially a lawyer of the caliber of Sir John. That is why my view is, yes, it cannot pass. I agree with you. But we need to understand the circumstances under which it comes.
Martin was bringing in the aspect of asset declaration.
Yeah.
What has it got to do with this? As in looking for a permanent fix, you know. And as you may have heard me in my take, it's my candid view that what you see there is actually the standard operating manual for these corrupt politicians.
I like that.
And they will steal and use the money to acquire, but they will acquire not in their name. Acquire in the name of other people secretly. So you hear him say, this one that I acquired through this company, that company, or jointly with someone else. How do you say that the asset declaration will fix it?
Yeah, so Sam, we all know that in Act 550, that's the Public Officers Declaration of Assets and Disqualification Act. It says that they should declare both properties they own directly and indirectly. So for me,
and their debts.
Excellent, liabilities, all those. So indirectly covers beneficial ownership. Beneficial ownership is the new buzzword in town. But long before it, the Act 550 1998 says indirectly. So indirectly is even wider than beneficial ownership, right? So that is it. But Sam, you see, as for the law, what we have, I like the way, you remember this morning, the way the clip about Seche Mensah Bones who complain about deficits in the law. That's not it. What we even have on the books now, if we were implementing that, would have been way gone. Rather than saying we want to make it 100%, then we spend 20 years on one law because we want to get 100%. How many times do you get 100% in school? Is that how we run life? So Sam, the big fix we need is that this asset declaration law by itself is not sufficient. Let's have that mandatory automatic appearance before Shraj, that when you are leaving office, go and account. I keep saying this, so I don't know how many people. Maybe next time I'll bring the GIAGE reports. I wanted to pass them this morning. Maybe if we place them on this,
so that what is deemed to be unexplained will just be taken away from you.
That's all. But right now, there's no automatic appearance before Shraj. And let's not forget that most of us, our citizens, we are scared of reporting. So instead of the adversarial system. So that will say Sam Ayenini versus Honorable Yusuf Chini. We want anonymous. So Honorable Yusuf Chini
doesn't want to be.
Yes. So we want to do it
runs deep in the family. Exactly. And that is the problem.
So we don't want to report. We don't want to report public officers. We rather want that automatically the public officer at the point of exit, whether he resigned or he was sacked, he goes before Shraj. And then once we know he's before Shraj, people will bring information.
Even in the current situation, should Shraj be accepting that you have not declared, somebody has reported you that you are not declared, in the course of you having been reported and in the investigations, you have now gone to declare. So it's okay, we leave you. That's what happened to the EC boss and a few other
One sentence, this is Sam. You know, the law is so vast. We all didn't know all of it from day one. I think Shraj can run some adverts for 2 months, informing all the public officers that, look, we are drawing a line under the sun. After these dates, please, the sanctions will be heftier, including you not taking office. So let's just say that the EC boss, Jim Mensah, she was just lucky. But Shraj should come out with a statement that, look, and not just a statement, run advert, because though we know ignorance of the law is no excuse, but as a city, I don't know all of the law.
The 2022 one, I see that the verification, they are giving that power to verify what you bring to the head of the department of your institution.
That's wrong.
Not the Auditor General.
Yeah, that's wrong. Look, let Auditor General continue his work. Rather, give him more money so that, Auditor Brown versus Attorney General. The Supreme Court has ruled that the Auditor General will determine the number of staff he needs and the rest. So that provision will be wrong. Auditor General will recruit more people. We have millions of graduates at home. We don't want an incestuous relationship. Your head of department, he's the one to verify your assets. So you scratch my back, I scratch your back. No, let the Auditor General do his work. The Supreme Court says Auditor General in employing his people is not subject to the Minister of Finance and the rest. Okay. Right. So Sam, and then this other thing, please. This you mentioned the draft earlier on this morning. Please, we need other provisions apart from automatic appearance before Shraj. Also, the spouses and other relations. Do you see this one? The U.S. example shows a good case. You see the U.S. Supreme Court Judge Clarence Thomas. In the U.S., because the law covers their spouses, when Clarence Thomas, he didn't feel for his wife, it became such a big scandal. Listen to this, and it's even recorded. They say, look, more significantly, a few years later, it was revealed that Justice Clarence Thomas had not disclosed his wife's income for a number of years, even though this was required by law. Justice Thomas said that this was inadvertent, and as a result of his not reading the format correctly. You see, even a big judge saying he hasn't read well. But year after year, he had clearly represented on these forms that his wife had no income, blah, blah. You go and then you see that the woman had earned $686,000. So what I'm saying, you see the scandal, you see how it's tainted him for life, he and his family and all that. So please, and even in Ghana, in the early 90s, under Rawlings regime, AJ Mafu, he put property in the name of his son and all that. So please,
it was taken.
Let's
include spouses. And before you come in, a good friend of mine, Cletus Alenga, has sent me something. He says the case you wanted to refer to is Metro Mass Transit versus Forestry Commission. And that in that case, the appeal presided over by our own Sir Dennis resolved that it is the Forestry Commission that has the power to make grants in forest reserves.
So that's the case.
Yeah,
so let me tell you, I sat on this same platform to lament the lacuna, but because we're not demonstrating commitment to the asset declaration. Now you appoint a public officer. The first thing after appointment that your appointee tells you is that you have to comply with the declaration of assets. Everybody, if your appointee doesn't tell you that, then that's a remiss. He has to tell you go and comply.
So and he insists that you do.
Insists that you do.
The law says you must declare before you assume office. How do you assume office and you haven't done it?
The second thing is that when the appointee fails, refuses, or neglects to do, we don't punish.
Yes.
It is only when we begin to punish that the seriousness of the non-compliance will be brought to the fore. That is the only way.
Okay.
The second thing is that we must allow for open declarations. So you don't seal it. You take it to the Auditor General.
Excellent.
You open it. Yeah. It's about profiling. If you have declared how much you earn, your income, and you are declaring properties, maybe properties in anticipation of acquisition. The Auditor General can say, okay, I'm interested in knowing the location of this property or that property. It's not everything that he's going to go to check. So it's profiling. So let's allow, and I contributed in Parliament during the time of Hotel Kufo. And I said it was about time that we allowed declarations for our wives and children. We can't continue to be pretending that people don't hide their properties.
So the advocacy must be on for the 2022 bill. That is, if that one too will not run into disuse like the 2015 and 2018 ones.
That's amendments.
Right. Well, what did you have to say about the will itself? People have raised a lot of issues about it. Company property is being willed.
Company property?
Yes.
Yeah, so madam, so how do you will company property? So where are the board of directors of the company?
Yes.
And the company, I mean, the Salmon is Salmon. The company is a distinct personality.
That's
so
right.
what are you doing?
The company is his alter ego.
Yeah.
Meaning that
No, you can't be that. That's what I'm saying, that as a people, we must begin to let others understand. The company is different from your person. I mean, you can't just say that a property held in the name of this company is going to this person.
Let's hear from Bright. And people raise issues about the way, when you look at, they're talking about this vehicle that purportedly his company was donating to the commission. And then that vehicle finds its way back into his own use as his private property. And then that his mining company, you know, he commandeers
forest guards.
a good number of forest guards to go and protect, you know.
And then before even you come, you know, we were all here lamenting about harvesting rose.
Let's hear
mining in forest reserve.
Let's hear Bryce Simmons.
Yes, I mean, it's been quite worrying trying to review some of the things that have gone on at the Forestry Commission. First of all, if you look at the Act very carefully, it's quite obvious that the chairperson has a very major role to play. But it doesn't appear as if, and this is based on our limited research into the matter, it's operating according to the Act in terms of decision making and the rest of it. The chief executive, which I think in the Act is referred to as the chief administrator, appeared to have unbounded discretion to do whatever he wanted. And some of the evidence that is now coming out about his involvement in very frightening conflict of interest situations, beyond just the lands that he's willed out, but in natural resource management generally, makes one wonder. First question: why was it that the president felt he was the right person to be the forestry commissioner, the chief executive of the Forestry Commission? What was the due diligence done? What was the references collected? Because typically national security has to look into these matters. And then once he was in that seat and had all these conflict of interest issues unresolved, what was the role of all the anti-corruption agencies that we have in Ghana, all the intelligence agencies that we have in Ghana? Why do we continue to pay them? Why do we continue to pay significant amount of money to maintain a BNI, a CID, an IOCO, a Ghana Police Service, a CID? I mean, we have so many institutions that we are resourcing with very scarce wherewithal. And if they cannot, if you have such blatant abuse of power, if they cannot get hint of it and warn the president, then I wonder what else is going on. It gives you an impression of a country that is heavily undergoverned, where the leaders don't really know what is going on, where they don't have a handle on a wide range of matters. And I think that needs to give us a lot of, it had to give us a lot of cause for anxiety. The other last point I wanted to make is that E1 154, Executive 154, must be repealed because it does not allow the Ghana Environmental Management Plan to proceed in the way it's been fashioned. It does not allow the structural plan that we have for Accra to proceed to be conformed with in the way and manner in which it has to be. I'll give you a very good example. Before we did the Kanda Highway, it was already captured in the master plan for Accra. When the time came, we had the resources to do the Kanda Highway. We had to go and break down all those houses. Luckily, this was the Rawlings regime, and I guess today we might probably not be able to do it. But the fact of the matter is that it was in the structural master plan, and that had to happen. That tells you that if you have serious governance, structural master plans must be obeyed. When the government decided to relinquish so much acreage in Achimota Forest, did they pay attention to the way that our existing master plans have already demarcated use for the zoo, for the seedling nursery, for the seismological research center? There are bats in Achimota Forest that carry viruses that have not been fully studied, and which international researchers have done research to tell us that these viruses can move from the bats into human beings, and they deserve better study. Some of that work continues to go on in that forest. All of it requires space. In fact, cutting deforestation is one of the quickest ways to get an interspecies jump from one virus to human beings or another type of species. And we've seen it all around the world. All of these matters are known to the right authorities. So when the president was taking the decision, who told him that 371 acres is all we need? Because when you just do a simple mathematical tallying, we need at least twice of that. And for IUCN principles, 2/3 of the forest have to be left the way it is. So I don't see how any serious technical advice could have led us to this path.
Thank you very much, Bright. And Bright, we have seen that you had some slides also that you were going to do for the flooding issue. We'll plead with you to hold on with it, and then we deal with it exclusively. Some people have been sending comments. We are running out of time, but I want to share just a few of them. Someone says the Achimota Forest and the Ramsar site issue you are talking about is only a tip of the iceberg. There's another development. You are a state, worker. You go to work in the morning, you return in the afternoon, and your bungalow has been sold. Hey. K. Amwan says, in the absence of any meaningful resolution for the Achimota lands and other government lands, can the Parliament of Ghana enact a law to stop any government from releasing and or selling any government lands? Obed Diama says, imagine Forestry Commission under 3 presidents at the least getting the accurate size of the Achimota Forest wrong, but now getting it right. What are the odds? Should we reevaluate all state lands over again? Who knows? DKS Francis says, the way the minister keeps insisting we won't allow any development to harm the forest after reclassification. I smell some hotels coming up, plus some high-end residential development. Okay, I've got many of your messages. Unfortunately, I cannot continue. My outfit, as always, is by Habil Scooter. You can contact them 0200 84 1988. My guests have been Bright Simmons, Honorary Vice President, Imani Africa, Samuel Abu Jinapor, MP Damongo, and Minister Lands and Natural Resources. Inus Husseini is former Minister Lands and Natural Resources. He's a lawyer. Martin Pebu is a rights activist. He's a lawyer. I'm Samson Ladi Anyanini. Have a good afternoon. God willing, next week we come your way with another edition of Newsfile.